Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In 2012, Attorney Elerizza A. Libiran-Meteoro issued post-dated checks to Marilio Lending Corporation for a personal loan. However, when deposited on their respective due dates, the checks were dishonored, either for being drawn against a closed account or due to insufficient funds. William S. Uy, a representative of Marilio Lending, attempted to contact Attorney Libiran-Meteoro regarding the dishonored checks, but she ignored his calls. Uy later discovered that Attorney Libiran-Meteoro had been previously suspended from the practice of law for 6 months due to gross misconduct. When Attorney Libiran-Meteoro continued to evade his attempts to communicate, Uy filed a complaint with the Integrated Bar of the Philippines, or the IBP, against her. After due investigation, the IBP Board of Governors recommended that Attorney Libiran-Meteoro be suspended from the practice of law for 1 year. Additionally, the IBP Board of Governors imposed a 15,000 peso fine on Attorney Libiran-Meteoro for her failure to file the required pleadings and for non-appearance at the mandatory conference despite due notice. The Supreme Court affirmed the findings of the IBP Board of Governors but increased the penalty to disbarment. Should lawyers be held administratively liable for issuing checks that are dishonored due to insufficient funds or due to a closed account? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 9th of May 2025, and today we will discuss whether lawyers are administratively liable for issuing bouncing checks within the context of the case of William S. Uy versus Attorney Elerizza A. Libiran-Meteoro, AC number 13368, decided on May 21, 2024. And joining us to talk about this case is Court of Appeals Associate Justice Geraldine C. Fiel-Macaraig, Vice Chairperson of the Department of Ethics and Judicial Conduct of the Philippine Judicial Academy. Hi, Justice Macaraig. Thanks for joining us and welcome to the Supreme Court Podcast.
Thank you, Attorney Mike. It's my pleasure to be here.
Justice, first off, why were the offenses of Attorney Libiran-Meteoro covered by the Code of Professional Responsibility and Accountability, or CIPRA, considering that CIPRA only took effect in 2023, while the acts complained of were committed in 2012?
Attorney Mike, members of the bar are now governed by the new Code of Professional Responsibility and Accountability, or the CIPRA, which took effect on May 30, 2023. Under Section 1 of the General Provisions, CIPRA will be applied to all pending and future cases, except to the extent that, in the opinion of the Supreme Court, its retroactive application would not be feasible or would work injustice. Thus, Attorney Libiran-Meteoro's acts were committed, although these were committed 11 years before the CIPRA took effect. The provisions of the CIPRA, nonetheless, served as a metric to determine her administrative liability.
In which provisions, Justice, in particular, under CIPRA, were violated by Attorney Libiran-Meteoro?
Attorney Libiran-Meteoro in this case was found to have violated Sections 1 and 2 of Canon 2, or the Canon on Propriety. Section 1 prohibits a lawyer from engaging in unlawful, dishonest, immoral, or deceitful conduct. Section 2 exhorts a lawyer to maintain a dignified conduct, that is, to respect the law, the courts, tribunal, and government agencies, their officials and employees, and act with courtesy, civility, fairness, and candor towards fellow members of the bar. The second paragraph of this section prohibits the lawyer from engaging in conduct that adversely reflects on one's fitness to practice law or behave in a scandalous manner, whether in public or private life, to the discredit of the legal profession.
So, Justice, does issuing bouncing checks for personal loans amount to gross misconduct sufficient for disbarment? Or should there be a separate action, say a criminal or civil case, to go after the lawyer?
Well, the issuance of bouncing checks may be performed by the lawyer in her personal capacity. The Supreme Court has subjected Attorney Meteoro to disciplinary sanctions because the act of issuing worthless checks and blatantly ignoring demands to pay are unlawful, dishonest, and deceitful. Batas Pambansa Bilang 22 penalizes the making or drawing and issuance of worthless checks which results in injury to the public. So as a member of the bar, the lawyer in this case was expected not only to know the deleterious effects of issuing worthless checks and the fact that it is prohibited by law, but be the first to faithfully abide by its provisions. To the Supreme Court, the lawyer fell short of the high standards of morality and integrity expected of members of the bar. Her deception and utter disregard of her financial obligations cast a dishonorable light on the supposedly dignified and noble profession she represents, for which she must be held accountable. Thus, in addition to available civil and criminal remedies, the lawyer in this case was administratively disciplined for issuing bouncing checks.
Justice, is there a need that the issuance of the bouncing check must be connected to the practice, legal practice?
It does not matter that the checks were issued in Attorney Libiran-Meteoro's personal capacity. It is settled rule that lawyers may be disciplined for any conduct, whether in their professional or in their private capacity, if such conduct renders them unfit to continue to be officers of the court. The lawyer's issuance of bouncing checks in their private capacity is therefore a ground for disciplinary action. There need not be a direct connection to the lawyer's practice.
So the act of issuing the bouncing checks itself. In fact, what's interesting here, Justice, is that this was not the first time that Attorney Libiran-Meteoro was penalized for the same act of issuing bouncing checks. In 2004, she was suspended for 6 months over a similar infraction. So what happened in that previous case and how significant was that for the current case?
You are correct, Attorney Mike, that this was not the first time that Attorney Meteoro was penalized. In an earlier case entitled Barrientos versus Libiran-Meteoro, a 2004 case, she issued 2 worthless checks in the amounts of 67,000 and 234,000 in favor of the complainants therein for payment of a pre-existing debt. The checks bounced due to insufficient funds. The lawyer later on committed to pay the complainants but failed many times to fulfill her promises. Thereafter, she gave the complainants a title of a parcel of land which she claimed was paid to her by a client. However, it turned out that the title was merely entrusted to her. The Supreme Court suspended Attorney Meteoro for 6 months from the practice of law as a penalty for issuing worthless checks, taking into consideration her partial payment of 50,000. Considering this previous offense of Attorney Meteoro, the Supreme Court found that the imposition of the supreme penalty of disbarment is warranted in this case. The Supreme Court noted that the lawyer already displayed quite flagrantly her propensity to defraud people by employing unlawful means to secure loans. She repeatedly failed to fulfill her promises to pay, which compelled the complainants to file suits against her. Undaunted, she repeated her infractions in this case and issued 2 worthless checks in favor of the complainant. She brazenly failed to pay her debt despite numerous demands and could not be contacted and in fact ignored the calls. The Supreme Court declared that Attorney Meteoro's history of deceiving individuals to part with their money in exchange for worthless checks reveals her propensity for dishonesty and fraud unfitting of a member of the bar.
So, Justice, it's not just the act of issuing a worthless check or a bouncing check alone that is a ground for disbarment, but the repeated issuance.
Yes, you are correct. The first issuance of the bouncing check was considered as an aggravating circumstance, and it was considered by the court in imposing the penalty of disbarment this time against.
But in the first time she did it, it wasn't a ground for disbarment.
It was
She
just
was
a
suspended.
suspension, but it was nonetheless considered as a serious offense already.
So what happens now to the money owed by Attorney Libiran-Meteoro to the lending company? Is the payment of civil liability already included in the remedies available to complainant in an administrative case, or must the complainants pursue separate civil cases for damages?
Attorney Libiran-Meteoro has to pay the money she owes to the lending company. Payment of civil liability is not included in the remedies available to a complainant in a disbarment case unless the same is intrinsically linked to a lawyer-client relationship. In this case, there was no lawyer-client relationship between Attorney Libiran-Meteoro and the complainant. The $245,000 owed by the lawyer was her personal obligation, not arising from a lawyer-client relationship. Thus, the creditor may still pursue the appropriate action to collect payment of the lawyer's debt.
I see. So it would have been a different case if she owed the money to a client, in which case the court could ask her to return the money in the same administrative case.
If the debt was incurred in relation to her relationship with the client as the lawyer.
And Justice, I note that in this case, there was a failure to update the contact information with the IBP of Attorney Meteoro. How does that affect due process in administrative proceedings? And can that be a ground for saying, I was deprived of due process because I was not contacted?
Okay, at the outset, under Section 19 of the revised IBP bylaws, a change in, among others, the residential or office address of members of the bar must be reported by the member concerned to the IBP chapter secretary within 60 days, who shall in turn promptly report the change to the national office. The failure to update constitutes a violation of IBP rules and issuances which, under Canon 6, Section 35A of the CIPRA, is punishable as a light offense. In this case, Attorney Libiran-Meteoro failed to report her change of addresses to the IBP, which apparently caused serious delays in the proceedings, as the IBP CBD had to try to serve her notices to several addresses. Thus, the lawyer was found guilty of violation of IBP rules and issuances governing membership of the IBP, and was imposed the penalty of a fine of 35,000 pesos.
On the other hand, Justice, what due process protections are afforded to lawyers in disciplinary proceedings if they fail to appear or if they fail to file pleadings despite being notified?
Attorney Mike, lawyers are presumed to have performed their duties in accordance with their oath and that the complainant has the burden to prove otherwise. In other words, the lawyer enjoys the legal presumption of innocence until the contrary is proved. In disbarment proceedings, the quantum of proof is substantial evidence, and the burden of proof is on the complainant to establish the allegations in the complaint. If the complainant fails to show in a satisfactory manner the facts upon which their accusation is based, the respondent lawyer is not even obliged to prove their defense. In one case, entitled De Ere versus Attorney Ruby, the Supreme Court held that there is nothing in the rules that authorizes the IBP to treat the respondent's silence as an admission of the complainant's allegations. Therefore, the failure to answer a complaint or appear is not equivalent to an admission of the charges against the lawyer. The investigating commissioner is still required to proceed with the investigation, and the investigating commissioner's conclusions must be based on substantial evidence.
But Justice, if a lawyer refuses to cooperate, does that non-cooperation reflect on his or her fitness to remain in the legal profession?
Of course, a lawyer's willful failure to cooperate with disciplinary authorities would subject such lawyer to disciplinary sanctions. So under Canon 6, Section 4 of the CIPRA, willful and deliberate disobedience to the orders of the IBP is a less serious offense which may be punished by suspension from the practice of law from 1 month to 6 months, revocation of notarial commission, or disqualification as a notary public for less than 2 years, or a fine within the range of 35,000 to 100,000.
So, Justice, it seems to be a balancing act. Because on the one hand, there is a presumption that lawyers are innocent with respect to the administrative case, but at the same time, they have an obligation to cooperate with the proceedings. And on another aspect also, how do you balance this? Ensuring that the legal profession can ensure accountability, while at the same time, the rights of the lawyers are also protected in an administrative case. So how do you balance that?
Foremost, an accusation of misconduct is just an accusation. It is not a finding of fact, much less a penalty. After all, lawyers, like any other accused, are presumed innocent. Hence, the duty to ensure accountability must always be balanced with the lawyer's fundamental rights. In this regard, having an independent disciplinary body, observing due process, and enforcing clear standards are vital key elements in the said balance. In Libiran versus Meteoro, it was once again illustrated and emphasized that the Supreme Court is the sole independent disciplinary body that may discipline and disbar erring lawyers. The Supreme Court is not bound by the findings of the IBP Commission on Bar Discipline or by the recommendation of the IBP Board of Governors. Here, due process was observed and clear standards were enforced. Attorney Libiran-Meteoro was given numerous opportunities to explain and submit evidence. However, she failed to do so despite notice. As to clear standards, lawyers, even before being admitted to the bar, are already aware that they are always and forever be subject to the high standards of morality, honesty, and integrity. Although the definitions of morality, honesty, and integrity vary with time, the lawyer's duty to observe them remains.
And Justice, just to close our discussion, what's our takeaway from this case? This is not a new case. There are lawyers who unfortunately issue bouncing checks. What's our message to them?
Well, our lawyers are the minuscule representations of our judicial system. Each lawyer really represents the judiciary. In fact, lawyers are the first legal refuge of the Filipinos. So in this sense, lawyers must at all times be faithful to their sworn duties. The success of the judiciary's efforts in preserving and maintaining its integrity requires the lawyer's cooperation. Although the Supreme Court has emphasized that disbarment must always be the last resort, disbarring a lawyer is sometimes inevitable. So the SC does not hesitate to cleanse the ranks of the legal profession of an unworthy member. To quote the Supreme Court in this case of Libiran-Meteoro, a speck of dirt in the roll of attorneys must be removed at all cost.
Interesting quote. Justice, thank you very much for joining us today.
You're most welcome. Thank you so much for having me also.
If you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library. Just search for William S. Uy versus Attorney Elerizza A. Libiran-Meteoro, AC number 13368. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court en banc has issued a temporary restraining order preventing the Legal Education Board, or LEB, from enforcing its resolutions which prohibited the Mindanao State University, or MSU College of Law, from opening its law programs in its Tawi-Tawi, Sulu, and Maguindanao campuses. The resolutions also revoked the accreditation of the MSU College of Law and ordered its closure, effective academic year 2025 to 2026. The SC required the LEB and the MSU to file the respective Memoranda of Authorities on the effect of Article 9, Section 16 of the Bangsamoro Organic Law on the jurisdiction of the LEB over the MSU within 15 days. The Supreme Court en banc has also issued a TRO stopping the Commission on Audit, or COA, from implementing its disallowance of the performance-based bonuses granted in 2012 to former Development Bank of the Philippines, or DBP President Francisco F. Del Rosario Jr. and DBP Center for Global Filipinos Officer Eleazar A. Reyes. The SC directed the COA to file its comment on the petition within 30 days. The SC has reiterated that courts are not bound by parental custody agreements when these do not serve the child's best interest. In a decision written by Senior Associate Justice Marvic MVF Leonen, the SC Second Division granted the petition filed by Jeffrey Rosacay M. Puerto and his parents, challenging a Court of Appeals ruling which upheld the validity of a compromise agreement between Jeffrey and Sheena Cabrillos, the mother of his child. Emphasizing the need for a proper trial for determination of parental custody for the child's best interest, the SC sent the case back to the family court. It also gave custody to petitioners Jeffrey and his parents, who have actual care of the child while the case remains pending. The SC stressed that compromise agreements between parties as to a child's custody are frowned upon. Courts should not simply approve custody agreements, but must ensure that the child's rights and welfare are protected. The SC has ruled that a duplicate or photocopy of original documents, whether in paper or electronic form, can be admitted as evidence in court, provided there is no genuine question regarding the original's authenticity or fairness in using the copy. In a panentia by Chief Justice Alexander G. Hesmundo, the SC's First Division upheld the conviction of Ibo Lastimosa for the murder of Ildefonso Vega Jr. in a case involving the use of a photocopy of Vega's death certificate as key evidence. The SC explained that under Rule 130, Section 4, Paragraph C of the 2019 Revised Rules on Evidence, a duplicate is admissible as the original unless there is a genuine question about the original's authenticity, or it would be unfair to use the duplicate. This rule applies to both paper-based and electronic documents, reflecting the modern reality where duplicates are often as reliable as originals. In this case, the photocopy of the death certificate, combined with the testimonies of Vega's wife and other eyewitnesses, sufficiently established that Vega died from gunshot wounds and that Lastimosa was responsible. The SC has reiterated that the presumption that a letter was properly delivered based on a post office's registry return receipt does not apply when strong evidence suggests otherwise. The SC's Third Division, through Associate Justice Samuel H. Garlan, held that the Civil Service Commission, or CSC, wrongly dismissed Victoria Labastida's appeal for being filed late. Remanding the case to the CSC, the SC concluded that Labastida had successfully overturned the presumption that the decision was properly served on June 14, 2016. The municipal government that employed Labastida had no record of the decision, nor the administrative case, and the registry return receipt bore the signature of an unidentified postal official. The SC also clarified that under the 1997 Rules of Civil Procedure, then in effect, a registry return receipt must be accompanied by a postmaster's affidavit confirming when, how, and to whom the delivery was made. This requirement remains under the 2019 Rules of Civil Procedure. On May 8, 2025, SC Associate Justice Alfredo Benjamin S. Caguiwa led the kickoff for pilot implementation of the Performance Development Framework for High-Performance Courts at Marco Polo Ortigas, Manila. Headed by the Committee on First and Second Level Courts Performance Evaluation, the project aims to promote excellence by providing a framework to track and evaluate the court's performance, as well as offering tools and trainings to make improvements. The Metropolitan Trial Courts of Mandaluyong, Municipal Trial Courts in cities of Antipolo, and Municipal Circuit Trial Courts of Maragondon, Ternate, Magallanes, Cavite are the pilot courts included in this implementation. The Office of the 2025 Sharia Special Bar Examinations has issued SSBE Bar Bulletin No. 5 on the policy on academic honesty, guidelines, undertakings, and rules of conduct for the 2025 SSBE. SSBE Chairperson Associate Justice Antonio Tico Jr. emphasized that the SSBE is an official activity of the Supreme Court. It is subject to the highest standards of decorum and academic integrity. Any form of dishonesty, disruption, interference, or misconduct may be punished as contempt of court and may serve as a ground for disqualification if committed by an examinee. The 2025 SSBE will be held on May 25 and 28, 2025. You are now up to date with the Philippine Supreme Court. I am Tiffany D. Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Atty. Karen Martinez, J. Rimpilio, and May Sibal as researchers, Don Ryan Balza, Victor Laranio, Lawrence Olanio, Austin Liscad, and Brian Austria as video and audio editors, and Tyke Flores and Jerome Batumalaki as web editors.